When should you put assets into a trust, and when should you hold them in your own name? Already own a home? Should you transfer it to a trust? Watch closely to avoid costly trial and error and to optimize taxes later. U.S. real estate investing. Choose sole ownership or living trust? Today we'll cover two common ways people hold title to a home in the U.S., sole ownership and trust ownership. First of all, what is sole ownership? Sole ownership means your name alone is on the property deed. You have full decision-making power, such as selling, renting out, refinancing, or transferring without anyone's consent. The process is simple. No company formation, no trust setup, no sharing of interests. Ideal for single owners, those wanting separate property before marriage, or anyone who wants full control. In terms of taxes, you're responsible for property tax, rental income tax, and capital gains tax. You can deduct eligible costs like repairs and maintenance. If you own alone, you also benefit from step-up in basis. For example, you bought a house at $400,000. 10 years later, at your death, the home is worth $900,000. Your heirs get a new tax basis of $900,000. If they sell it for $900,000, there's no gain, so no capital gains tax at that moment. That's a 100% step up in basis. But there are risks, because the asset is in your personal name. Lawsuits, debts, or legal disputes can reach the property. The sole ownership truths many first-time buyers miss. There's no liability shield like an LLC or tenancy by the entirety. With sole ownership, your home can still be pursued for debts. If you're sued, for example, after a car accident and insurance isn't enough, the home may be used to satisfy judgments. If your business is sued for breach of contract, a court could order the home seized, even if the property wasn't involved. About a state issue, if an owner dies without a will, the property will have to go through the probate process, which can be slow, costly, and potentially contentious. Spouses or children don't get automatic authority to manage the asset, a court must approve. A common solution is transferring the title into a living trust. Why trust ownership can optimize U.S. real estate investing? A living trust isn't a person or a company. It's a legal structure created to manage assets for beneficiaries. In simple terms, a trust is a legal agreement. You remain the owner, but place assets into a fund you create and manage. There are three key roles. First is grantor, who creates the trust and transfers assets into it. Next is trustee, the assets manager per the trust's instructions. And third is the beneficiary, the one receiving the benefits or property. These three people will contact each other as follows. First is the person who establishes the trust, the grantor, who will transfer assets into the trust. For example, houses, land, stocks, so on, can all be transferred into the trust. And then the trustee will be responsible for following the instructions given by the person who established the trust to manage the assets. And then the beneficiary will receive the profits, that portion of assets, from the distribution of the trustee. The grantor can also serve as trustee and beneficiary while alive. When the grantor dies, the successor trustee continues management and distributes assets as the trust directs. Boosting your asset management efficiency with trust ownership. The biggest advantage is avoiding probate. No court process means major time and cost savings and fewer disputes. Assets pass directly to beneficiaries exactly as written in the trust. Let's take an example. A person A sets up a revocable living trust, puts his house and savings into it. He appoints his daughter as the trustee and his wife as the beneficiary. When he dies, his daughter only needs to get a death certificate to continue managing the trust and transfer the assets to her mother without having to go through court. Compared to owning in personal name, this method saves a lot of money and time. It provides powerful planning options like set conditions for inheritance. For example, conditions could be set up like you have to graduate from university to receive the money, or if you are over 30 years old, you will receive 50% of the assets. If you are over 50 years old, you will receive the remaining 50%. Assign specific assets to specific heirs, for instance, home to first child, company shares to second child. Restrict use of funds, like for education or healthcare purposes only. Curb overspending by having the trustee distribute wisely. It also offers flexibility. You can change beneficiaries or trustees. A revocable trust lets you update terms anytime. You keep full control while alive. And you can name a backup trustee. What to know before you set up trust ownership. You must fund the trust, which means legally retitle assets into the trust's name. If you don't, the trust is just a paper without any control over those assets. Update the trust after major life or asset changes so instructions stay accurate. Typical cost for setting up a trust is around $1,000 to $3,000. Given the advantages, this can be a smart investment in orderly control and risk management. Sole ownership versus trust ownership. Which fits you better? Sole ownership is simple, fast, and low cost. But without a will, heirs face probate. Lawsuits can threaten the asset. Court proceedings are public. Trust ownership takes more time and setup cost. Over time it reduces risk and avoids probate. You keep control while alive and create a clear transfer plan after death. Trusts protect privacy and are powerful for estate planning, especially for larger or complex families. Revocable trust versus irrevocable trust. Understand to choose wisely. Revocable trust is a kind of trust that you can amend or revoke anytime. You keep control and assets are still treated as personal, so taxes and liabilities remain. Often used to avoid probate while maintaining control. Irrevocable trust is the type that cannot be changed unilaterally. Assets are no longer personal. This can provide lawsuit protection and reduce estate tax, often used by those with significant assets or higher liability exposure. Revocable trusts usually offer fewer tax benefits than irrevocable trusts. A further benefit of trusts is privacy. If assets avoid court, details remain internal rather than public. Revocable trust versus irrevocable trust. Key differences few people know. Can be edited? Revocable is yes. Irrevocable is no. Controlling? Revocable is yes. Irrevocable is no. Properties is still your personal assets? Revocable is yes. Irrevocable is no. Avoid probate? Both have it. Lawsuit protection? Revocable is no. Irrevocable is yes. Step up in basis? Revocable is generally yes, while irrevocable may not. It depends on the specific content. It also depends on how it is written in the trust. In terms of security, both of these types are highly secure. Estate tax impact? Revocable trust is not reduced because it's still your personal property. Irrevocable trust can be reduced because it's no longer your personal property. Regarding the cost of establishment and maintenance, the cost of revocable trust is usually lower and it will have a one-time cost. Of course, there will be maintenance costs if there is an update each time. The cost of irrevocable trust is usually higher and usually requires a lawyer to maintain and monitor it throughout. Who are these two types suitable for? The revocable trust is suitable for those who want to avoid inheritance court but still retain property rights. The irrevocable trust is suitable for those with large assets who want to protect assets from litigation, reduce estate taxes, or have complex gift or donation plans. Expert answers common living trust frequently asked questions. Can I transfer from sole ownership to a trust? Yes. Create a trust and sign a grant deed. Because taxes may be affected, consult a qualified professional first. Is there transfer tax when moving property into a trust? Usually no, because you remain the owner. Verify other taxes before transferring, like property tax for example. Do trusts exempt capital gains when selling a home? The answer is no. Income in a revocable trust is still personal. However, you may qualify for the primary home exclusion under IRS rules if you meet the requirement that you are the trust holder, have lived in the house for at least 2 out of 5 years, and have not used the tax exemption in the last 2 years. Take an example like this: you bought a house at $400,000. 8 years later it's $700,000 and you sell it. If it's your primary home and you're single, you may exclude up to $250,000 of gain tax. Can I co-own with others while using a trust? Absolutely. For example, if you and your wife set up a joint living trust or a portion of the assets in the trust, then the remaining assets can be shared with a third person, then it will be a trust plus the name of a third person. In the end it would be joint tenancy, or the title can reflect percentages of the trust. Can I move assets without selling? The answer is yes. You can make it by funding the trust, often by recording a new grant deed into the trust. Do I still need a will if I have a trust? It better be. Creating a pour-over will to capture assets not yet transferred to the trust is also a thing to do. Can I set up a trust if I'm unmarried? Of course. Anyone can establish it, regardless of marital status. How long can a trust last? Depends on state law. Some can span multiple generations. Do I need a lawyer? You can create one yourself, but legal guidance helps ensure the trust is correctly drafted and aligned with your goals. Can I place mortgaged property into a trust? Yes, but you'll need lender consent. Does a trust affect borrowing? It possibly is. Lenders will review trust terms to confirm eligibility and collateral control. Can a trust hold assets in multiple states? Absolutely. A trust can include assets across states and help avoid multiple state probate processes. Every ownership method has pros and cons. Choose sole ownership for simplicity and speed. Choose trust ownership to transfer assets without court, keep privacy, and follow your wishes precisely. If you want to limit disputes further, consider entities like an LLC or a corporation for certain situations. For deeper dives on LLCs, corporations, joint tenancy, or trusts, check out other videos on my channel. Before choosing, consult an attorney or qualified advisor, because your first decision can have long-term legal and financial impact. If you found this video helpful, don't forget to like and share it with anyone who needs it. Subscribe to my channel so you don't miss the next videos. Thank you.
Real estate and mortgage broker Danguard, with experience in over 1,000 loan applications and real estate transactions, aims to provide you with useful and general knowledge about this field. For advice on each specific case, please contact via email or website provided below the video. Don't forget to click like and subscribe to the channel to stay updated with the latest information from Danguard.